Hi everyone, my name is Verdie Atienza and I'm a senior immigration attorney at Davies and Associates LLC. We are a business immigration law firm headquartered in New York. I manage the L1 and E2 visas practice team of the firm. This video is the second part of a series of videos where I focus on discussing the specific requirements for the E2 treaty investor visa. In the previous video, I discussed the first requirement, which is the nationality requirement. In that video, I explained that you can only apply for the E2 treaty investor visa if you are a national of a treaty country. And if you're interested to know if your country is a treaty country, you can go to the Department of State website to check and confirm. The second requirement to qualify to apply for the E2 visa is that you must have invested or you must be in the process of actively investing in the E2 enterprise. So there are several things to consider to determine whether or not you meet the requirements. There are three requirements to prove that you have invested or you are actively in the process of investing in the E2 treaty enterprise. The first requirement is that you as a treaty investor applicant must prove that you have legitimate control and possession of your funds. Essentially, the US government is primarily interested to prove that the funds that you're investing in your E2 treaty enterprise come from legitimate means. So the treaty investor applicant would have to submit documentation as to the source of the funds. So if your investment comes from your employment income, you generally need to submit the proof of your employment. You can include pay slips and pay stubs and even bank statements. If the investment funds come from business income, you'd have to submit documentation about the company, financial statements, and bank statements as well. You are not required to submit a dollar for dollar accounting, but obviously the more documentation that can support your assertion as to the source of your funds, the better for your E2 application. As some of you may know, the investment funds for E2 application purposes can also be gifted to the treaty investor applicant. In that case, the donor or the gifter would also need to submit documentation as to the source of the funds that the treaty investor applicant will be investing in the E2 enterprise. As a treaty investor applicant, you also must prove that all funds invested must be at risk and irrevocably committed. To put it into context, there are different ways by which you can apply for an E2 visa. You can acquire an existing business, you can buy a franchise, or you can establish your own startup. In all of these cases or scenarios, you still would need to prove that the funds are at risk and irrevocably committed. So that's generally easy to show if you're acquiring an existing business or if you're buying a franchise, because you obviously need to already pay the purchase price or the franchise fees at the time you file the application. In case you establish a startup, you need to be able to show that you've made significant business expenses, and any of the unspent funds would have to be placed or deposited in an escrow account. If you're acquiring an existing business or if you are going for a franchise, there are potentially ways to minimize your risk. The visa or the sale of the existing business could potentially be contingent on the approval of the visa application. The funds would have to be placed in an escrow account subject to release to the seller upon approval of the E2 visa. If you're establishing a startup, you don't necessarily have to risk all of the investment funds prior to filing the application. Obviously, we would encourage you to make as many or as significant business expenses as possible so that you can demonstrate to the consulate or to the USCIS that you are irrevocably committed to the E2 enterprise. But you can still choose to place a significant portion of the funds in an escrow account that's governed by an agreement that will make sure that the funds will only be dispersed for the business expenses of the company. But obviously, aside from putting funds in the escrow account, you still need to be ready to demonstrate that you've made significant business expenses. So typically, if you are committing at least $100,000 in your E2 enterprise, you'd probably want to show that you've made significant business expenses, probably between $30,000 to $40,000, and then the rest of the funds you can place in an escrow account. The escrow account is a legally recognized mechanism to prove that you are irrevocably committing the funds to the E2 enterprise. If you have funds sitting in the company's bank account, these funds are generally not considered as irrevocably committed. So it is always recommended that you set up an escrow account so that any unspent funds can be placed in that account, and the escrow agent will basically guarantee to the US government that the funds will only be used for the business expenses of the company. This way, you can minimize the risk on your part and still you're still able to comply with the irrevocability of investment requirement. And lastly, to prove that you have invested in the E2 enterprise, you need to demonstrate that the E2 company is already operational, or if not, it should be imminently operational. The US government will not approve your E2 visa application merely based on your desire to set up the company or on the promise to set up a company and get it operational and up and running. In one way, it is a catch-22 situation where you have to already take concrete steps to get the company up and running or as close to operational as possible before you apply. Basically, you need to demonstrate that you have already signed a lease, applied for employer identification number, opened a bank account. You should probably have a website up and running, and you should have purchased whatever you need to get the business up and running.